Hello everybody and welcome to our Think House Autumn Seminar. I'm David Lowe, one of the organisers of Think House, our seminars aimed at in-house lawyers. Thank you very much for joining us today. I'm just really sorry that we are here still in a virtual Zoom world and I'm not seeing you all in person in our offices for obvious reasons, although I hope that this might be the beginning of the end. Today's session is Pen and War Before Court and War. But before I talk about that and introduce that, just wanted to flag that this is the fourth of our autumn sessions. Last week we had data privacy and antitrust update, and just this morning we had an in-house lawyer's guide to COP26, and concluding with this, what goes wrong, what do you do when contracts go wrong session. Next week we'll be sending around a link and all of the materials for all four talks, so that if you've missed one of them, you'll be able to watch it, and of course share it with your colleagues within your teams. You'd be very welcome to do that. For example, we're aware of in-house legal teams using the slides in this recorded session to run them as team sessions internally, and you're very welcome to do that. Anyway, today is about what happens when contracts go wrong. Pen and jaw before court and war. We're very conscious that, especially in times like these now, furlough, for example, has ended today. Contracts under distress are a common feature. We've obviously been dealing with lots of force majeure queries as we went through COVID, and there is a predicted spike in insolvency. Contracts will be under stress, and therefore we thought it'd be useful to give a practical guide about what to do when contracts go wrong. And to do that, I'm joined today by Emma Carr, a partner in our dispute resolution group, to talk with me about how to deal with when contracts go wrong. So I'll be doing the non-contentious side to it. I lead our commercial contracts team. And so over the years, I've worked with people like Emma and understood what to do when contracts go wrong. And indeed, most importantly, what I can do in my contracts to make them right. Perhaps Emma, you could just introduce yourself.
Yeah, hi, thanks David. Hi everyone. Yeah, as David said, I'm a partner in our dispute resolution group. My focus is on general commercial litigation. So the handling, preventing, resolving of disputes arising from breaches of contract and negligence. So yeah, I'll be dealing with the contentious side of things today, of what to do when contracts go wrong and practical steps you can take to avoid stepping foot into the courtroom.
Susie, can we have the next slide? So this is what we're going to cover today. We're obviously going to be looking at how you act when contracts go wrong. And we're going to be moving from drafting to prevent that in the first place to early indicators and practical steps to take before stepping foot in a courtroom. And we're going to start with the drafting. So we're going to sort of leap to learn the lessons of hindsight to then go, well, what would we do in the contracts, and do that first, because we're conscious that's probably what you can take away today, deal with this afternoon and tomorrow, and the contracts on your desk, immediate actions, things you can do to try and make sure you don't end up talking to somebody like Emma. But then, having set that scene about what the lessons are in hindsight, we'll then talk about how you can spot a dispute looming and what you should do in those early stages. I'm obviously going to lead on the what to do in drafting your contracts, and Emma's going to lead on what to do when the dispute is looming. By all means, do submit questions into the Q&A. We'll gather them all together and ask those at the end. So we will come in within about an hour today, of which about 45 minutes will be Emma and I talking, and 15 minutes of questions. Please grab the next slide, please. So starting with me about what are the lessons of hindsight, and I've put up here on this slide basic issues that of course you'll be rolling your eyes and going, yeah, of course I know that, but I think it's really interesting because all too often when a dispute starts looming, it often starts with somebody calling me up and going, just want you to have a quick look at this contract, we might need to terminate it, or I just want to talk over what you think this clause means, or what the liability cap is, or what you think of this. And so the early beginnings of dispute, somebody often asks me a question, and when I ask to see the contract, well, all too often the contract, the final signed complete form of the contract isn't readily available. So I might be asked to look at the Word version that we think was the penultimate version, but nobody's quite sure. Or a contract that everyone knows has been varied, but nobody can put their hand on the variations. Or perhaps the contractual parties to the contract aren't actually very clear, because it just said XYZ and ABC, but does that mean XYZ Holdings Limited or XYZ LLC or XYZ UK Limited? Or maybe XYZ doesn't exist anymore and there's been a corporate reorganization. Who's the contract now with? Or there's a contract and there's a variation, but the variation mentions there's another variation, but nobody can find that one. And that happens a lot. And we also see that when we're doing corporate support, doing due diligence for our corporate colleagues, when somebody's buying a company, is most of the contracts we see in data rooms are incomplete in some way. They rarely have all the schedules. They're rarely all completely signed. And so there is a really important issue here for you to take away internally about contract management systems to make sure you're doing your best to have somewhere the complete contract readily available. Keep an eye out for expired contracts, because all too often people might have a 3-year contract with a fixed term, and then it says at the end of that term it ends. And of course, we're now 5 years on. What happens now? Was it the old contract? Does that just roll on? Or are we in a new unwritten contract? It's all a rather uncomfortable place, which if at the time of expiry, somebody had put in place, maybe just an email or whatever was required of the contract to extend or roll on the contract so it rolls for 3 months, or term of 1 3 months notice, it would all be so much clearer. Emma, have you come across any issues in that area?
Yeah, I was just reminding myself of, yeah, we have had it a couple of times where one particular slightly hairy case was when we had to issue proceedings and we didn't know whether we had the fully signed version of the contract. We had pretty much a penultimate draft, but not the full signed version. And no one really knew whether there were any differences, but we had to issue proceedings on that basis. And it was only when we got disclosure from the other side that and their defence that we saw it was fine. Actually, the contract was fine, but it was a bit fly by the seat of your pants and quite, scary at the time. So having that complete copy of a contract, shouldn't be underthought of, because it is really important, particularly to make sure you've got the right advice and that you're taking the right actions in accordance with that contract.
Yeah, and I've had situations where we've had to ask the other side for a copy of the final contract. What better signal to signal that there's a dispute looming than the fact that you're having to ask the other side for a copy of the contract, and blows potentially your cover if you're weighing up what to do. Also, just a flag, we talked about ThinkHouse contract updates before about the Rock advertising case, which made it clear that courts expect people to comply with the variation clause in their contracts. And if you don't, there's a good chance your variation might not work. So again, all goes back to having good contract management and administration. Susan, could we have the next slide, please? My next basic step is law and jurisdiction. And I just think it's really important that you make it a habit to include in every contract you're dealing with a law and jurisdiction clause. And if it's a very short contract, maybe it's just a short letter, don't forget, you can get this down to 5 words, English law and English courts. If you simply said that at the end of the letter, that is far, far better than nothing. Okay, it's not as good as the full boilerplate law and jurisdiction clause, but at least it gives a strong indication of the party's intentions. And personally, just because it's a domestic contract, by which I mean an English company contracting with another English company, where performance of the contract is in England and there's no international content, even then I put a law and jurisdiction clause in just to make the habit, to make sure that when it really matters, where there is some international content, I definitely put a law and jurisdiction clause. It's just a good habit to get into. And anyway, you'd be surprised actually how many contracts actually are international. Might be an English seller and an English buyer, but perhaps performance is in Germany, or perhaps the assets of those companies are in a different country, or perhaps it's a Scottish company. So sometimes it's not actually obvious whether it's domestic or international. So again, just keep in it a clear law and jurisdiction clause. Emma, have you come across situations where there are no clear law or jurisdiction clauses?
I have, and unfortunately it just, delays the process because you end up having a dispute within a dispute about what the law and jurisdiction is. So, I fully endorse your suggestion. It's certainly something I look for. It's one of the first things I look for, A, to see if I can actually advise and it's within my competence, but B, just so that we know we're doing and we're acting according to the contract. So yeah, I endorse what you say about it being paramount to get that in the contract.
And don't do what one of my clients did, which is they'd obviously had a bit of a debate with the other side about which law. It was a Brazilian company, an English company. So was it going to be English law? Was it going to be Brazilian law? Was it going to be another law? And so the compromise they decided on was to make the contract subject to Brazilian and English law, which I think is possibly even worse than having no law in it, because what does that mean? A combination of English and Brazilian law. So if you do get into a negotiation about which law or which jurisdiction, obviously you'll have a view about which one you prefer. But ultimately, it's important that you do find a compromise where you've identified a single law and a single jurisdiction that applies. And frankly, it's better to have a less than ideal choice of law and jurisdiction than to have to be silent, because as Emma says, you're going to have a dispute about dispute. And as external lawyers rub our hands in glee at all the money we're going to make about having this futile argument about which law and court is going to be before we even get to the real dispute. Next slide, please. The next key point is around termination. Having a dispute is really expensive. Having a dispute uses lots of time. Having a dispute uses lots of energy, is a massive distraction. So much better if something's going wrong in your contract, if you can just simply go, okay, we're just going to draw a line on this and terminate, end it, and step away. And we and the supplier can go off and do our own thing somewhere else and avoid putting the energy, time, effort into it. And so it is really important that your contract is really clear about how and when it can be ended. I'm going to really hammer it into my junior lawyers and supervising. I want the contract to be really clear when it starts, and I want it to be really clear when it ends or expires, and how I can end it. Because if it's not clear, then if there is a dispute arising, we're into then a difficult situation of trying to work out what our options are. If it's fixed term, be clear what happens at the end. Does it roll on, terminal next month's notice? Does it automatically expire? Just what does happen? Because if it just simply says this contract will end after 3 years, full stop, then there's going to be a debate then about, well, because of course, by now you're now in year 5, 2 years later, just about what the mechanism is and about whether that contract applies at all. Because the courts aren't really going to want to imply anything unless they really have to. And so they're not going to feel very comfortable about just assuming the old contract carried on. I think another good habit to get into as a default position is to always have a termination at will clause, so that you can terminate at any time on X months notice. Now, sure, that's the kind of thing that will attract negotiation in a substantial contract, but it's best to at least start with having one of those clauses in and have it in your standard terms. So that is your default position from which you can then negotiate. Now, you might have, in a big contract, you might have to pay a price. You might have a right to terminate on 6 months' notice at any time, but it's subject to paying certain costs because, of course, the supplier will be saying, well, my price is a 5-year price. And if you terminate at halfway through year 1, then I've lost loads of money. Well, I would observe that it's better to have that and know what the price of terminating at will is before you go into the contract than to be trying to negotiate your way out of a long-term contract that isn't going very well. When after year 2, your chief executive is slamming his or her fist on the table going, just get rid of this, how much better is it to say, that's fine, I can do it, I can serve 6 months notice of termination now, but it will cost us X million. Are we happy to do that, or do we want to press on with the dispute? Emma, what's your experience?
Slightly, I suppose I'd want to pick up on the notice point really, actually. So where you do have termination at will, but it's subject to, 6 months, like you said, in your example, notice, whatever. We've had it before where clients have come to us thinking they've terminated because they've serve notice, but they've not then followed the notice provisions that are often in the contract. So I suppose aligned to your termination point, I'd also make the point about making sure you follow the process and procedure for serving that notice to the letter, because otherwise you can find yourself in a situation where you've invalidated the notice, if you like, and therefore you're potentially wrongfully terminating the contract and putting yourself in a position where you could be accused of repudiating the contract. So I would make that point. That was fortunately in that case we got to it soon enough. We had to reserve notice in accordance with the contract, and so the only price to pay really for failing to do it in the first place was it just added a couple of weeks delay. But it is something that I would advise to look at.
We've spotted in the Q&A somebody making the very good point commercially that termination at will works both ways. It's likely that if you've asked the right to terminate at will, the other party will, and so you might find yourself being terminated in a situation where you won't. So obviously you need to keep an eye out for the commercials on that, but I would recommend it as a sort of at least a default position. But as Emma says, if you are going to use it, make sure you do it properly. I've just been dealing the last couple of days with a similar argument where somebody had terminated one of those contracts where they were locked in for 3 years. It automatically rolls on for another 3 years unless they're given notice to not renew at least 6 months due to before the end. She did give the notice in, but she didn't express it in the way in which the contract's written. She said she'd terminated, and then we're having a big argument about whether the contract has ended and when it ended. And this is a phone system for a chain of retail stores, which is going to be really important. My final point on there is avoid a perpetual contract. Well, I think we all as lawyers would cringe at the idea of perpetual contracts. I mean, some of us will even remember vaguely, isn't there some law about perpetuities or whatever? Isn't that just a horrible place to go? Well, obviously having a contract that potentially can never end is not attractive. It's not attractive to then go to Emma, hey Emma, this contract says it goes on forever. Help me get out of this contract, because of course a court's starting point is to read what the contract says. So do make sure that your contract does eventually end in some way. Who commercially would ever want to enter into a perpetual contract? So do make sure there's a clear end at some point or some means of ending it. Next slide, please, Susie. Obviously, if you do have a long-term contract with no break, then bear in mind you're now in a sort of high-risk environment. I think of some of the really big contracts I've done over the years, which are for long terms, they often lead to disputes, and it's typically around change. Contracts are pretty good usually. People are pretty good at making a judgment about what today's deal is and whether it's worth it. But we're pretty good at, and pretty bad rather, at anticipating change, about the fact that in a 5-year contract, there's a reasonable chance the law might well change or stuff will happen. Who 5 years ago would have predicted COVID, for example? Who would have predicted a fuel problem? Although many of us will remember the fuel problem back in 2000, but we do actually have quite short memories and think it's never going to happen again. So be very wary of long-term contracts with no breaks. And if you are, focused particularly on the change mechanism, about how it's going to work if there's a change, if sales fall, if the market changes, the law changes, whether it's worth the risk. And make sure, as I said, think about putting in a break clause, so even if you have to pay a break fee. Next slide, please, Susie. Now, when I talk to people about disputes, and I'm sure Emma is going to back this up, disputes don't usually arise because about something that's in the liability clause or the assignment clause or the law and jurisdiction clause. The disputes almost always start with an argument about price, performance, or delay. So obviously make sure those are clear. And they're all commercial issues, aren't they? And this is why you'll be hammering into your commercial teams. Look, you've got to make this clear. If I can't understand this pricing clause, there's no chance a judge has got reading and understanding it, or there's a good chance they're going to read it in a different way. We've got to make this clear, or for performance or for delay. So do make sure it's clear. Do make sure change is thought about. For example, at the very least, it's a contract going over a year, then you probably want some kind of indexation price adjustment. And then basic things to make sure that the contract delivers. Governance is really important, not to us as lawyers, because it's just people talking to you, but commercially, having a framework in which people are regularly talking, dealing with small issues before they become big issues is really important. And that's why service levels can often be very useful, because then it gives some kind of benchmark expectation and signal something's going wrong. Next slide, please, Susie. But turning to the legal stuff, here's a list of things with hindsight you will wish you had when you have a dispute. You'll want a clear liability clause because you'll want to be able to advise your business just exactly where you are and the other party is on liability. That convoluted, complex liability clause, which nobody ever really understands, isn't going to be very helpful if you're then having to weigh up whether you've got liability limited to the value of the contract or £5 million or unlimited. And of course, where you are in those positions will influence the nature of the dispute. I think we all know with COVID having happened, CO2 shortages, fuel shortages, semiconductor shortages, etc., the importance of having clear force majeure clauses, just define what is a force majeure and what isn't, what happens if there's a force majeure, etc. Emma's already talked about making sure notices are given in accordance with the contract. So therefore, actually, really boring clause at the back of the contract about whether you give notices by in person or recorded delivery or whatever suddenly becomes really important, because Emma's going to be poring all over it, working out how many days, etc. So if you haven't got a very clear clause, you're going to have it already a significant problem about how do I give notice effectively? Can I give notice in time? And a sort of key hate of mine is I still see so many notices clauses that refer to fax. Fax is dead. Almost nobody has a fax machine or knows where it is. When you're just given a gift to the other party if you leave the fax clause in, because then there's going to be well, I sent you a fax notice. Did you not get it? And immediately into a dispute about a dispute. We've already talked about dispute escalation resolution, and Emma will be talking more about that later. And then I've talked about boring notice clause. Well, even more boring is things like the waiver clause, the entire agreement clause, the third party clause. They're all really tedious, aren't they? Nobody really cares about them when you're drafting the contract. But suddenly, when there's a dispute, all of this becomes really important. Can my group companies also take the benefit of this contract? We'll turn on the third parties clause. Just exactly, can I argue, can we, with the tender, the nice fluffy tender that promised me the world, is that part of the contract? Well, the entire agreement clause is going to be really important. Have they waived this issue? Have I waived it? Well, suddenly your waiver clause is going to become really important. And as I said, the law and jurisdiction clause is also important. Emma, is there anything on that you want to add?
No, although I did just quickly check our business cards to check we don't any longer put our fax number on there, and we're okay. It's not on there anymore. But yeah, you're right. It was only the other day I saw fax in there, and I suddenly thought, it was a relatively new contract as well. I just thought, crikey, bonkers. But definitely no reference to fax.
And these are all reasons why the boilerplate's important. Your commercial colleagues are going, oh, do I really have to have all this? Can't we just say I'm going to buy X for Y on a certain date? And the answer to their question is, of course you can. The contract can be really, really, really short, but you might live there to end and regret it, because all that boilerplate is all to just help build a foundation for the contract to sort of make sure it runs in the way people actually expect it. Next slide, please, Susie. And now over to you, Emma.
Thank you, David. All right, so as David said, the best way to avoid disputes arising in the first place is to have a really well-drafted contract to start with. But what about where that's not possible? So, for example, where you inherit a contract from a predecessor, or, heavens forbid, the business has entered into a contract without involving legal. What about those circumstances? What are the early indicators that those contracts might be about to go wrong? Well, as it says on the slide, it depends very much whether you're acting as a supplier or as a customer, but some common red flag indicators can include a breakdown in communications. So you're in effect being stonewalled by the other party. They're not responding to emails, they're not returning your calls, they're not supplying the documents and information they're supposed to be, they're missing deadlines. That can be a common red flag. Also, when they're getting overtly contractual over the most minor of points, so they start citing contract references at you and they're doing so on a regular basis, it's not conclusive there's a problem, but it's a good indicator. Likewise with lateness of payment or delivery, that also can be a classic sign of trouble brewing. And finally, a loss of departures at senior management or personnel level, or indeed a mass exodus of people at the other party generally can indicate there's problems going on internally, which can obviously have an external adverse impact later down the line. So they're just some things to watch for. David, have you got any other indicators to add in your experience?
Yeah, I mean, I think looking out for a counterparty who's looking for a dispute or a way out of a contract, you know, they start muttering, this contract's not profitable, you know. That for me would be an alarm bell that something's going on. You know, they may well have contracted cheaply and are starting to regret it, and therefore they'll start trying to wriggle. Or the contract manager that you're dealing with every day is a lovely person, and then suddenly he starts saying, oh, I need to check that with my boss, I need to escalate that to somebody else. And as part of that, Emma, I mean, you've talked about breakdown in communications where they stop communicating, or the opposite is when suddenly the chatty contract manager, always happy to do it over the phone, suddenly changes their communications. Suddenly everything is by email and they insist on recording things, having minutes of meetings when you have never had minutes of meetings. Those changes in behaviour for me, I think, are key red flags.
Yeah, or the without prejudice label kind of just gets applied to everything willy-nilly regardless, and you're suddenly like, well, why are they putting this on all of the time, or referring to, you know, words like off the record or whatever. Yeah, they're also twitchy moments, I think, that can prick your ears. So they are important ones to look out for. Susie, have you got the next slide, please? Okay, so you've got some of those early indicators kind of starting to arise. What should you do and what should you be advising the business to do? Well, first and foremost, probably the most important thing is to really encourage them to get you involved from an early stage. So whether you're openly involved or not, or whether you're just, you know, in the background as a watching brief, your involvement can be really, really useful, because not only can you ensure that, you know, you're complying with the contract and all the procedures set out in there, and making sure no early own goals are scored. I think there's also a real benefit in having your objectivity and impartiality. So the person on the ground who's dealing with it day to day has almost like a personal vested interest in the dispute. So being one step removed from that, I think you can add that extra impartiality and objectivity, which can perhaps help unlock a dispute far quicker than might otherwise be the case. Secondly, encouraging open dialogue. So as Winston Churchill's attributed as saying, and we heavily borrowed to title this session, to jaw is better than to war. Talk is really cheap. So encouraging and keeping those channels of communication open can mean that you can potentially wrestle the dispute to the ground before it grows limbs and snowballs and turns into an expensive dispute. So really do encourage that. Thirdly, I would use the time to get relevant facts and papers in order. David and I have already spoken about the importance of getting that contract in order, making sure you've got the final copy, making sure you've got all the schedules together, because often the schedules can be just as important as the main body of the contract. But get those together, and also find out the basics, you know, when, where, what's happened, because all of this fact-finding can save you time later on and help put you on the front foot. Whilst on the subject of documents, preservation of documents is also key. Most businesses now have a routine destruction process for data and documents. It's very important that as soon as, you know, you get the first whiff of a dispute, that that destruction process is suspended straight away. Not only is that important from a practical point of view, so that you don't, you know, destroy a crucial document that you may later want to rely on, but it's also in accordance now with your disclosure obligations under the CPR, particularly if you're in the business and property courts. So it's really important that you adhere to that. Informing key stakeholders is another thing to think about doing. So, obey the doctrine of no surprises. I'm not suggesting here that, you brief the CEO ad nauseum as to what's going on, but making sure that the relevant decision makers at the end of the day just have an inkling of what's going on can mean you can save time later on in having to brief them from scratch. And finally, review the contract. Sounds obvious, but not always done. There are some key clauses to look for, which I'll go on to talk about in a moment. But the other reason it's really important to review the contract is for those reasons David and I have touched on, to make sure you're following the process and procedures from the outset, so you don't inadvertently do something which might be called into question later on or limit your recovery. So follow those processes, for example, the notice procedures, anything else that comes up. So important to review the contract. Next slide, please, Susie.
Oh, just before we go on there,
yeah.
Just talking about dialogue and talking, I particularly remember a situation with two companies who were fierce rivals in their sector, a bit like Coca-Cola and Pepsi, but it wasn't about those two, but it's a similar sort of rivalry. And they'd had a history of decade of litigation, low-grade litigation, arguing with each other on anything they could find, complaining about each other to antitrust authorities and so forth. The head of legal at one of those companies, his deputy had actually moved across to the other company a couple of years before, so much bitterness, but they had a low-grade dispute and it was starting to get serious and talk of injunctions. And actually this is where the lawyers played a great role, because the head of legal called up the person who used to work with at the other company and just said, look, this is madness. We're going to end up in litigation about something that probably neither of us want to. It's not really worth us both washing, having our dirty washing out in public. Can we not work together to try and resolve the dispute? And that was a good example of the in-house lawyers on both sides trying to bring some calm to the dispute and find a sensible commercial resolution rather than find themselves in the court.
Yeah, thanks, David. I think that's also where that objectivity point I made before comes back in. It's just that one step removed from the people that are dealing with it on the ground with kind of a vested interest and slightly more emotional about it. I think it does. It is worth its weight. Sorry, Susie, next slide. Okay, so as I said, when reviewing the contract, there's some key dispute resolution clauses to look out for. So David's already spoken about governing law, but it's important that you're aware of what law the contract's written under. Likewise with jurisdiction, what dispute resolution forum the parties signed up to. The most common ones are litigation and arbitration, but by no means are they exclusive. So check that and check which forum you're dealing with. ADR, alternative dispute resolution. Is there a clause which obliges the parties to undertake negotiation or mediation before launching into court? There often is in contracts. Sometimes it's a standalone clause, and other times it's part of a more detailed dispute escalation clause. Next slide, please, Susie. So just taking a little bit more time over dispute escalation clauses. You'll know you have one in your contract if there is a clause which sets out various steps that need to be taken and various processes that need to happen before you can step into the courtroom. So there are various steps that need to be taken in order to resolve a dispute, and you need to go through each and every one of them. Normally, how they start is with some very light touch discussions between the key people dealing with the contract. And what you see happen is those discussions ramp up in terms of seniority of who's having them within the company before you get to a CEO level, perhaps. And then moving on to some more formal mediation. And that having to be gone through before you even think about issuing claims or arbitration notices. If there is a dispute escalation clause in your contract, it's really important that you follow it because it may be enforced by the courts at a later date. And obviously, if you've gone ahead and issued proceedings before the satisfaction of all those steps, then there's the possibility that the commencement of those proceedings may be found to be invalid. So it's important that you enforce them. And in the notes to these slides, when they do come round, there is the cases in there as to how the law's changed, as to how it views the enforcement of dispute escalation clauses. But the law as at to date is very much that provided they are drafted with sufficient certainty, they are enforceable and so do need to be followed. Dispute escalation clauses and alternative dispute resolution clauses provide a really good opportunity for the parties to resolve their disputes. And going back to that, keeping dialogue open, they encourage that. But even if your contract doesn't have one, then it still might be a good idea, and there's nothing to stop you trying to agree one with the other side. Why would they do that? Why would you do that? Well, because alternative dispute resolution can be really cheap and quick and effective, far more so than going to court. And likewise, because they're often conducted on a without prejudice basis, it really does encourage that open dialogue between the parties. So there's, people aren't holding back, concerned that what they say might be used against them at a later date. So that open dialogue can really encourage a speedy resolution. David, I don't know, I know your dispute escalation clauses are quite detailed, but have you got a view on how you found them?
Yeah, I mean, I include them in all but the simplest of contracts now, because I think encouraging people to talk in a formal way can only be a good thing. And who wants to drag the CEO into the dispute unless they have to? It's a good way of motivating the management team further down to try their best to resolve it, because who wants to go to the CEO and go, oh God, I've got this small difficult dispute, but I'm having to go through a formal dispute escalation team. You don't really want to waste the CEO's time. So I think they're really important and valuable clauses. And I'm also conscious that, over the years, I've certainly seen a number of clients where there is a moment of rage within an organization about what the other party has done, and a business team that's insisted on rapid legal action. And proceedings are issued, and litigation starts, and everyone's sort of rattling their swords, etc. But of course, then the business moves on, and litigation doesn't move on. Litigation goes on and on for years, but the business has moved on, and a couple of years pass, and then they're starting to go, well, why are we even doing this litigation? Why are we incurring all these huge sums of money? Well, who cares about this anymore? And then regretting that rage that led to this spark at the beginning. And so I think dispute escalation clauses are quite a helpful way of just trying to help bring some calm, and time is quite valuable and useful in those situations to ensure that people aren't getting trigger happy.
Yeah, they can definitely help take the heat, I think, out of some of the situation, and different people getting involved can have different perspectives. So yeah, well, I'm all for them. But okay, sorry, next slide, please, Susie. So the two most common forms of alternative dispute resolution are negotiation and mediation. Negotiation, what is it? Well, in effect, it's the parties just trying to resolve the dispute in a neutral setting between themselves. So it can happen in writing or in person. The main benefit is that because it's not an aggressive step like issuing proceedings, it can help encourage that dialogue and maintain the commercial relationship. And likewise, because the without prejudice rule will generally apply, people, as I said, are generally feel more free to speak, because they've got the comfort of knowing any statement they make won't later be used against them in court. So it does, encourage that open dialogue. When will statements be held without prejudice? Well, they'll be held without prejudice in the negotiation if they are made in a genuine attempt to settle the dispute. So if they weren't made in a genuine attempt, then just because it was part of the negotiation, the without prejudice rule won't necessarily apply and statements will be admissible. But, to avoid confusion, I would suggest if you think it is without prejudice, label it as such or state it to be as such. This won't automatically mean it becomes without prejudice just because you've said it is or put the label on it. It still has to be a genuine attempt to settle to qualify for being without prejudice. But certainly by labeling it or stating it as such, it will help identify intentions to any third party. Likewise, though, failing to label something without prejudice isn't fatal to it being without prejudice. It's all about whether the communication concerned a genuine attempt to settle. So if it didn't, then it's unlikely to be WP, even if it's labelled as such. But if it did and it was a genuine attempt to settle, then that's likely to be upheld. David, have you come across a negotiation? Have you been involved in those?
Yeah. Someone shouldn't tell you about Emma, really, because I should have involved you, shouldn't I? I mean, one observation is, of course, although if it is without prejudice, the court never gets to know about what was said in the room, but you can't forget, and the other party can't forget what was said. So you do need to be, I think, mindful of, there might be some issues. You don't want the other side to think that you've got a really weak legal case, for example. So you do need to be thoughtful of that. It may well influence the attitude and tactics of the other party. But weighing up that against the fact that the openness and flexibility in negotiations is really valuable. I mean, many, and this is where we'll come on to this in mediation as well, is that many disputes are resolved through commercial flexibility. Look, if we can deal with this issue here, that other contract we've got will reduce our prices, or we'll open up that factory in Ghana rather than Nigeria, or whatever it is that the accommodation between the parties. A flexibility in a way that ultimately a court judgment is not going to deliver. Court judgment is just going to say, yes, you were or weren't in breach of contract, and these are the damages you have to pay. And usually, we all know, don't we, in our own relationships, money might make us feel better, but it doesn't actually make us happy, while the negotiations can do.
Yeah, and that's right. Next slide, please, Susie. Mediation is the other common form of ADR. So, mediation is very similar to negotiation, except that it brings in a third-party independent, the mediator, who comes in to try and help resolve the dispute and break any deadlock between the parties. Although mediations and mediators can be evaluative, so you can instruct them to come up with a decision based on what he or she has heard of each side's case. The role they generally play, it's more of a facilitative nature. So what they'll do is they'll shuttle between the parties and act as a go-between, trying to encourage a settlement and compromise that both parties are comfortable with. The benefits of mediation is that it's confidential, which is great. And like negotiation, it's also without prejudice. It's also a voluntary process, although I say that with some caveats. So it's voluntary, you don't have to do it. But there's been a whole plethora of case law which has issued cost penalties for an unreasonable refusal to mediate. So, although it is voluntary, beware that if you do refuse to mediate, it can lead to cost penalties later down the line if the court finds that your refusal was unreasonable. Mediation can be a really powerful and cost-effective tool. It's been estimated that over 80% of mediations result in settlements. So, really good success rate, and obviously much cheaper and quicker than going to court. They can be attended with or without legal support. Very much depends on the strategy. You might want to wheel in the entire legal team to show the weight of seriousness you're attributing to the dispute. Likewise, you might not want anyone from legal there to show the disregard you give for the dispute. So it all comes down to strategy, really, as to who attends and who doesn't, as well as from a practical point of view. In terms of the mediation process itself, for those of you who haven't been involved in one, in a typical mediation, the parties will appoint a mediator, and the mediator will ask both parties, or however many parties there are, to provide a position statement, so a document which sets out their position in advance of the mediation, and to exchange those documents with the other side. Then there'll be the day of the hearing itself. So what the mediator will do is bring everybody into one room and invite both parties to make short opening statements, just setting out what their position is and highlighting any key concerns to them. And then what the mediator will generally do is send the parties back to their respective rooms. So if you've just got a dispute involving two parties, you'll generally find 3 rooms in any mediation, 1 room for each of the parties, and then a large room which the mediator can use and bring all the parties back to. But once the parties go to their own rooms, the mediator will shuttle between the 2 rooms, trying to broker a deal, occasionally bringing the parties back to the main room if he thinks it's beneficial to do so. Mediation, they're a long day, and sometimes more than one day. The ones we generally see go in the diary for a whole day, and it really is a whole day. I think people arrive with, yeah, we're going to get a settlement today, and by lunchtime, everyone's really quite tired already. It's quite an exhausting day. So, you need to be alive for that, I think, and ready for it, because it can be really quite draining. Often, everyone thinks the settlement's going to get signed there and then. And like I said, 80% of them, according to some statistics, settle. And I think that's right. But in all but a handful of the cases, the mediations I've attended over the years haven't actually settled on the day. What's happened is they've settled in, the days or even weeks in some cases after the mediation, when people have been able to go back, reflect, have some sleep, and speak to various decision makers within the business, and take things away. So it will come into a consideration later on, but don't think all is lost if the mediation doesn't result in a settlement on the day. If it does, great. The mediator will often help with that settlement agreement, and once that settlement agreement is signed, it becomes binding. But as I said, don't despair if it doesn't result in a settlement there and then. Thanks, Susie, you've already moved on to that slide. So this slide is just covering off some of the points to consider if you're thinking of proposing mediation to the other side, or alternatively, if you receive a request from them to mediate. So points to consider: which mediation procedure you're going to adopt. So you could adopt a model proposed by a mediation service provider, such as the Centre of Effective Dispute Resolution, CEDA, and they have their own model, or you could adopt another model entirely. It really is flexible. Costs of the mediator and also your own costs. The general position is that the costs of the mediator are split equally between the two parties, and that you bear your own costs. That doesn't always have to be the case. I had a mediation a few years back where the other side point blank refused to pay for any mediator. And so my client, because it was so keen to go to mediation and to avoid court, did agree to pay the total cost of the mediator. So, although the usual position is 50-50, it doesn't have to be that way. Location: where will the mediation be held? It can be held at either party's commercial premises or at their lawyer's offices. It's one to consider, I think, with strategy. So is there a benefit to having the mediation held on your own turf or at your own lawyer's offices? It sounds a minor point, but I have attended mediations where we've been hosted by the other side. We've been put in rooms without windows. We've almost been starved out and not fed. We've certainly been caffeined out and not given coffee. There is something to be said for the logistical ease of knowing where you are, having control on catering, knowing where the toilets are. The psychology as well, I think, of having it in your own office. But likewise, might be a benefit to attending their offices, or even having it in a neutral setting for that reason, but it's something else to think about. Who will be the mediator? I suppose if you're in a dispute with the other side, trying to then get them to agree on your choice of mediator is probably not without risk. What we often see drafted is, each party will put forward 3 candidates, and then they'll try and decide one of those. If that doesn't result in a mediator being appointed, then often what you see is a default nominating party being specified. So, for example, Centre of Effective Dispute Resolution, CEDA, as I mentioned, are often stated to be the nominated party. In terms of who's the mediator as well, also think about what type of dispute you're dealing with. It doesn't necessarily have to be a lawyer who's the mediator. If you're dealing with an accountancy issue, it might be better somebody who is an accounting professional, and for the nominating party to be the Chartered Institute of Accountants, for example, rather than the CEDA. So there's something else to think about. Attendance, we've already talked about, whether legal come or legal don't, and what message that conveys. But the other thing to think about is the level of seniority of the commercial people that are attending. There is nothing worse than, and I speak from experience, of going through an entire day's mediation to get to a point where you think you're going to get something signed off and in writing, and Joe Bloggs from the other side turns around and says, oh, actually, I haven't got the authority to sign off on this. I need to make a call. I need to speak to somebody, and then that person's not available because they've not been put on notice they need to be available. So I suppose key thing is make sure whoever's attending and from either party, has the decision-making power or has that mandate to make a decision, or alternatively has a hotline to somebody who is available, who will be able to give that authority. Situation often also happens with insurers where you need insurers okay to it, so make sure they're on standby if they need to sign off on any settlement. Also, how long to give the mediation? As I've said, majority of mine have settled in the days after, so you do want to put an agreed period of time on it, because you don't want the mediation and the period post-mediation to carry on forever without you being able to take the next step. But you don't want it to happen too soon either, and then just run the risk of the benefits of mediation not being fully felt. And then finally, facilitative or evaluative. As I said, most of the time the mediator is facilitative, but they can also be evaluative. So you can ask them to make a decision. Again, very much depends on the strength of your case, because that could go against you, of course. Last slide, please, Susie.
Just we get there on the mediation.
You had a mediation, didn't you? You're doing my job again, yeah.
Yeah, I did my first, well, I didn't do it. I was involved in my first ever mediation during lockdown. I guess the reason I don't normally get involved is, thankfully, it's not usually my contract that's a dispute, it's somebody else's contract that I've had nothing to do with. So when I get a phone call going, I've got a problem with this contract, I hand it over to somebody like Emma. But actually on this occasion, it was an agreement I had drafted and heavily negotiated, and it had gone wrong. And thankfully it was legally absolutely clear that the other party had a minimum purchase obligation, and the wording was absolutely solid. They were bound to rights, but they were refusing to buy the minimum purchase, and this was worth several £1 million. And the client asked me to remain involved while one of our litigation partners did the mediation bit. And I found it a really interesting process. I think first of all, I think it was really valuable in that, okay, yeah, we all had to spend a long day, and that meant tying up senior executives on both sides, board members on both sides for a whole day who really didn't want to do it. That's one of the reasons for doing it, because you get their attention, you get their irritation at being involved and wanting to get rid of this, and gets the dispute sorted before you end up in the long, laborious and expensive litigation. It's always going to be cheaper than litigation, even though at the time it feels like it's a very sort of heavy commitment. I also thought it was great how flexible it was. The other side put their forward position paper, and I felt like they got a barrister involved, and they sent this sort of 20-side position paper quoting case law. We sent back a 2-sided one focusing on the commercials. You're allowed to do that, whichever way you think is best to put in your position, because we thought their legal position was really flimsy. In fact, that's why we thought they spent 20 pages writing it out, because they knew at their heart it was really flimsy.
Yeah.
What was really valuable, I think, was our frustration, as my client's frustration, was never being able to have a proper commercial conversation with the party on the side about resolving it. It gone very quickly to their lawyers' hands, who had been really aggressive from day one, and therefore we never felt we'd have a commercial conversation. And now the other side couldn't escape. They had to listen to our commercial proposal for how we were willing to do it. Really interesting, the mediator at work, because he puts you under real pressure. And you almost start thinking he's on the other side. He's on the opposite side of each other. That he was pushing us, going, no, you're not really going to go to court over this. You're not got credible evidence on this. Really pushing it, and we're having to remind our client, well, he's doing that. He's just doing that to hear what we say, because he's got to go back to the other side and put our strongest position as he shuttled back and forth. Yeah. And all of this was on Zoom, because of course we're in the deepest, darkest lockdown before Christmas last year. And that worked really well, actually. I was a bit skeptical, because we all hate being on Zoom and Teams call, don't we? But I found the structure of it worked really well, and that there was a plenary room where we could all be, and then the mediator very slickly moved us into separate rooms, then would put the commercial guys in a little room by themselves, etc., etc. So all in all, it's really good. As Emma said, it was a long day. It started at 10 o'clock in the morning. We thought it would be done by mid-afternoon. It was sort of 1 o'clock in the morning before actually the other client decided to go to bed. But as Emma said, 2 days later, we got a signed settlement agreement.
Yeah. I think that's a really good point as well, David, that you make. And more often than not, clients will say to me, look, I'm sure this mediator's on the other side's payroll, because, you know, they're picking all these arguments in our case and they seem to be really roughing us up. And yeah, that is what the mediator does, but rest assured, he or she will be doing it with the other side in their room. Their job is to try and get that agreement, that compromise. And so, you know, they'll go to those lengths to do that. Okay, so conscious of time, when to get external support involved. David's just pointed out one of the downsides of getting legal and external legal involved too soon, you know, taking it out of the commercial hands. But mediation's a juncture that external support often gets involved in. Their attendance at the mediation can help add weight, but even if they don't attend, just being in the background, helping to prepare position papers and advise on strategy for the day can be helpful. They could be involved much sooner as well. Obviously, dealing with disputes is time consuming, so additional support enabling you to get on with your day job can be helpful, and it also adds a further layer of impartiality. But likewise, at the end, clients often go through all the dispute escalation steps themselves and only involve external legal, you know, when court looks imminent. So it really is a flexible process, and it's one where, you know, external support can dip in and out as and when required. So there are just a few things to consider which might help you resolve the matter in a quicker and cheaper way than launching into lengthy and costly court proceedings from the outset. I suppose we'd be really interested to hear now from you as to whether you've got any questions or war stories that you'd like to share of when contracts go wrong or of ADR. So David, over to you, and questions, please.
Yeah, I've been looking at the questions that have been coming in. We've had one actually going back to the beginning where we talked about law and jurisdiction, about where you're having a dispute with the other party about which law and which jurisdiction you contract. What could you do, sort of neutral options? So Emma, I'll lead on that, and you can see if you have anything to chip in. But you know, the classic situation is usually an international contract. Maybe you're a UK company, so you might start off with English law, and you may wade up whether you're going to have English courts or arbitration. And then the other party, I don't know, maybe they're based in China, will go, actually, no, we want Chinese law and Chinese courts or whatever. How do you resolve that? Because both parties feels like they'll lose face by agreeing to the other law and jurisdiction.
Yeah, I think it very much depends on where they're based. You know, if I couldn't have English law and jurisdiction, I'd ideally want something in Europe, just because it'd be easy to enforce, or something in a jurisdiction where I know they would recognise any order made in this country. So, you know, you'd look at who signed up to the New York Convention, for example. You just want to make sure anything was enforceable. So, and the other party would want to do likewise. So I think you just have to try and find a compromise on that basis, really. Which isn't a full answer, I'm afraid, but it depends on where the parties are based.
Yeah, and I think that's really important, because in my example there with China, of course, the Chinese courts will not really take much heed of another country's courts. Arbitration is probably going to be much more successful in China, and actually, I tend in international cross-border contracts end up with arbitration because it diffuses the debate about jurisdiction. I mean, on law, but on contract, I do a lot of international contracts, and many of you will know, heavily involved in things like Incoterms. Is over the years I've come to the view that actually contract law around the world is pretty similar, because funny enough, buying and selling goods and services causes the same problems wherever you go. So don't get too hung up on the law. It's better to have a clear and certain law than to leave it open. I do usually try to persuade people that English law actually is an international reputable law with judges or arbitrators that are recognised as tend not to be corruption, etc. So my starting point was to try to persuade people to stick to English law, ready access to justice, ready access to lawyers with English law experience. But what kind of countries I go to for compromises, well, especially if I've gone down arbitration, Sweden, I often use. Everyone feels very comfortable with Scandinavian involvement. New York, sometimes, although, you know, getting anywhere near anything to do US comes with a fear of finding yourself, even with an arbitration, some kind of US litigation is always a bit of a worry. Singapore is often seen, particularly for Asian contracts, as a sort of relatively neutral place. Dubai, I'm seeing increasingly often as a sort of reasonably trusted third-party country. Switzerland, but I don't really, their law, it is very code-based and has some particular quirks. It's not my favorite law, better than no law. And of course, I think most people have confidence in the neutrality or the perceived neutrality of Switzerland. So I think there are quite a few options, and I think it does depend on where the parties are, where the dispute's likely to be, and the nature of the contract. Another question, Emma, we've had is about document destruction. Obviously, many businesses have policies to destroy documents, and obviously in the modern world, you know, getting rid of data and documents are on your IT system. I mean, practical tips for how in-house lawyers should manage that when the first whiff of the dispute comes up?
Yeah, I think it goes back to, you know, what to do when those early indicators arise, you know, sending that message out, making sure it's documented, that you've gone to the key stakeholders of that information, you know, to stop the destruction or to suspend it. So making sure you've done that. We also, as external lawyers, particularly if the matter is likely to proceed in the business and property courts now, will immediately notify you of the need to do that, because we'll ultimately have to confirm to the court that we advised you on that basis. And I think the same would apply to you in House Legal as well. Practical tips, I mean, it's kind of, unless you can get involved and encourage those when they're entering into contracts to make sure they store them in the right way and to keep you involved, which goes back to their keeping legal involved, just so that, you know, if nothing else, you can make sure that all the variations are in one place, all the schedules are in one place, and there is that database available, because it can, you know, prove quite unruly, really, depending on how many variations and iterations you go through of the contract. But for reasons we've both stated, having that fully completed copy of the contract is really of key importance if and when you get into dispute territory.
And I guess a key part of this is to bear in mind how important it is to you to have your records. You know, often it will turn on who emailed who on what day. And if you haven't got the email, you wouldn't even know that you've got that weakness in your position, or indeed strength in your position. So that document retention is important strategically as well as from a legal perspective. Yeah. Right, it's now 2:32, so I'm conscious we've overrun a little bit, and I don't want to take any more of your time, so I'm sure you've all got commitments this afternoon. So I just want to thank you very much for joining us today for this webinar on when contracts go wrong. As I said, we will be sending out a link next week with a recording of this seminar and indeed all the other seminars we've done, and this slides and all the materials. And we'll also be mopping up the questions that we haven't had a chance to answer to, and hopefully make contact with you directly. So thank you very much.